Hello and welcome to the People's Law School. Today we're going to be talking about family law, and with us is Carolyn Keely, a local attorney, and John Reed, also here in Paducah. My name is Cynthia Sanderson, the family court judge in McCracken County. Well, John, what's going on with regard to children in today's courts? Let's take up the issue of paternity first.
Okay. You probably should ask Carolyn that. She may know more about that than I do. As you know, there are more and more children being born out of wedlock, and we are seeing those cases in court a lot more. I practiced long enough that I can remember the pre-DNA days when we did more simple blood tests that sort of said maybe this is the father and maybe it's not, and certainly that's an improvement, I think, as far as you're concerned as a judge, and also for a litigant to know for sure whether you really are the father of a child. I have an interesting case, by the way. I'm going to throw this out. Situation, I should say. Have you had any in vitro fertilization cases where eggs or sperm were donated? Because there's a real issue that comes up with whether or not a mother who gives birth, if she didn't supply the egg, whether she is in fact the mother. Have you had a reverse paternity case where they said even though the child was born of the woman and everybody saw it, someone tried to come in and say that's not her child?
No, I have not. I'm hoping I don't get confronted with that issue.
So that you ask what's happening. That's the most recent thing I've been involved in. It's been a rather unique thing, although there was a lot of legal paperwork signed in the fertility clinic where this was done, and I think it's pretty clear what a judge will do. When people sign paperwork and say this is so-and-so's child and we've just donated a part to help make a child, I don't think there'll be any issue, but I have had that raised recently.
It seems to me that the harder issue along those lines, as far as new things that are happening, would be when you have a surrogate mother. When a mother is basically contracted with, or her bills are paid, or the purpose is to get another woman to bear the child of the husband, for example, with the understanding that that child will be then adopted by the parents. I don't know if you've had any of those cases either. I haven't seen one of those. Have you?
I haven't had one. That's what they're trying to argue in this case, even though it's really the reverse, because the paperwork was all signed for the mother who went through the pregnancy for it to be her child, even though biologically, if you did a DNA test, it wouldn't be her child. Right. And I haven't seen any reported cases in Kentucky on any of these issues, but I suspect in the next few years you're going to see them and we're going to see them both.
Okay. Carolyn, as you know, most paternity cases are brought in behalf of the mother, yes, usually by the local child support office, in an effort to collect child support in behalf of the state oftentimes, or certainly in behalf of the mother. But is it appropriate for an expecting father to also consider pursuing paternity establishment?
Absolutely, and I have seen this and have handled cases like this. It's called a voluntary paternity petition, and basically a father who, and sometimes they're not absolutely sure. I mean, there really is no way a father can be certain that that woman is carrying his child without a DNA test. But a father can file a petition for the court to order him to issue a paternity order stating that he is the legal father of the child. If both parties agree that the child is, and this is any kind of a paternity case, if both parties agree, either by affidavit or sworn testimony in court, that the child is biologically this man's, then the court, as I understand, will usually issue an order saying so. I always advise my fathers, perhaps I'm a cynic, but I always advise my fathers to get a DNA test, either court ordered or voluntarily, because I've had just one too many situations where that DNA test came back negative for paternity. And you can do that in a voluntary paternity case also, request a paternity or a DNA test. The father, of course, once he does that, and if it is his, then of course he not only gets the glory and joy of having a child, but he also gets to pay child support usually. But if he is found to be the father, he has equal rights to custody of the child. Even if he hasn't seen the mother for the whole 9 months, he may still go into court and request one of the types of custody, either joint custody, sole custody. He certainly has a right to visitation to the child, either the standard visitation schedule that the court has or some other type of agreed upon visitation schedule.
Now, either one of you can answer this. The standard that the court uses when deciding custody in paternity cases, different or not different from that of married folks?
The same standard as far as
It's the same. It's the same standard.
The best interest test. What's in the
Yes.
best interest of the child? Which parent can provide the best environment for the child?
Right, and as you know, carrying a child for 9 months doesn't necessarily mandate that parent is the better of the two.
No,
In
it
fact,
doesn't.
that has little to do with it. In fact, sometimes in this day and age, we find mothers that are heavily involved with drug use while they're carrying their children, and that certainly is a huge strike against the mother because of how she has abused her child in utero.
I get a lot of the child support office, at least the one in McCracken County. They are usually only involved in paternity cases where whoever has custody of the child, and it's the mother usually.
And you're talking physical custody, not legal custody.
Right, physical custody or a grandparent maybe, will apply for some kind of state aid on behalf of the child. That will trigger the state's involvement in this family, at which time the child support office wants to find the father, or sometimes it's both parents that they're looking for to pay child support. I guess the rationale is that the state and the citizens of the community should not have to pay for this child if there is an adult parent that has the ability to pay for the child. That's when the child support office then goes and looks for the child. The mother will write down names. I've seen cases where we've been through like three men. You know, she writes down one man and that DNA test comes back negative, and then she goes to another one. I had one recently where the child was 14 years old, and I represented the father. There had been like 2 or 3 tries before then to locate a father, and at 14 years old, he had a mandated DNA test. It came back positive. He had, quote, been with her one time, okay, which should teach somebody a lesson. And child support was ordered, and visitation for that 14-year-old child. Because the child was so old, so much time, there is a time frame on going back to collect child support. But men should beware of what they're doing. It is no longer just a problem for women who have children out of wedlock. It is also a problem and a joy for the men, and they need to pay attention to what they're doing.
Right.
The other side of that is sometimes those men have been married for 16 years, and I had one of those, and it's real hard to explain to your wife why you have a 14-year-old when you've been married 16 years, a 14-year-old by someone other than your wife.
Well,
so it can be sort of, I don't think it was a joy for those men.
No, it probably
to find
wasn't, nor their wives. Here's an interesting thing, and I bet you've had a case like this, and I know you've seen cases like this. It's a 16-year-old marriage. They're getting a divorce, and the father says, I'm not sure that 15-year-old child we have is mine, and I want a DNA test. What happens with those situations? It's a marriage.
Well, I think I've read some recent law that the courts are going to lock you into that because of the I forget what the legal term is, but it's kind of a putative. It's kind of a you're stopped from asserting otherwise because the child has been seeing you as a parent all of these years, and am I right?
I think there's a relatively recent case because I had always sort of taken the position that it was it was more than a presumption. I mean, there is, and I can't remember how the statute reads, but it definitely reads any child born of the marriage, maybe it does say is presumed to be a child of the marriage. Any child born during the marriage is presumed to be a child of the marriage. I've had cases in prior years and before you were even on the bench where that issue came up, and I have had judges let men out of that obligation. I think that situation I had, though, there was another father who actually did want to step in,
Right.
and I'm not sure if that would have any bearing on this case that you and I are both thinking about that came from the Court of Appeals, where they did seem to say, tough luck, you've raised the child as your own. And I mean, I understand the court's position, and there's two sides to this, and we could argue two sides of everything we talk about today. From the standpoint, if you're getting divorced and your marriage has been miserable for a long time, and then you find out the child you thought was yours isn't even yours, you could certainly see from a guy's perspective maybe that he doesn't like the fact he's going to pay child support for maybe 10 or 12 years more if the child's young.
Well, but the flip side of that is if the parent does not want out of the obligation and the mother perhaps wants to use it against him in a custody battle and say, you're not really the father, you have no standing here, and that would be so unfair to both the parent, the father who has nurtured this child, as well as the child.
And if we look at the child, just if the child has always thought this was their parent, what are you doing to that child when you now tell them when they're 10 or 12 years old, oh, by the way, daddy's not your daddy?
I think that was the gist of the legal argument in that recent case that he and I are referring to, the impact that it would have on the child. And it's nice to know that the courts are giving more consideration to the interest of the child than just the legalities of the matter, because technically I could see where a court could easily go the other way if they were just looking at biologically.
And you wonder if it would make a difference if the child in that case had been 18 months old.
Yeah.
Would they have been more inclined then to have said, wait, you need to go find this child's real father. He needs his real father. His real father needs to know who he is. And there wouldn't be perhaps as much attachment. I wouldn't think there would be as much attachment with a really young child as there would be with an older child.
Well, there was a recent case, and I don't know if it's one you all are thinking about or not, because I think the crux of this was that the father had been paying child support for some time, then discovered the child was not his, and he wanted to get reimbursed for his back child support for the child that was in fact born during the marriage. And I believe the court required sent it back for a hearing on whether or not the mother had perpetrated a fraud on the husband with regard to the back child support. So that's another issue in there, not just the paternity and custody, but if you have been paying child support for some years on a child that turns out not to be yours, do you get it back?
Not
maybe.
Usually.
Yeah.
Well, in this case, it was a fraudulent. If it was determined that she knew that it wasn't his, then yeah.
I'm still waiting to see my first refund of child support case. There may be one. I've never been exposed to it.
Yeah.
Well, and you can go on these paternity cases because the state will file for medicals as well. Even if the father didn't have a clue that there was a woman out there pregnant by his child, and she went in and she had a state medical care, provided her with her hospital expenses and the birthing expenses for this child, the state, when they find that father, is going to ask him to pay those medical expenses too.
Right. Well, let's switch subjects here for a moment. I mentioned something earlier about children that are drug dependent when they're born. That brings on a whole nother court that we deal with in family law, and that is dependency, neglect, and abuse. Sometimes we use the acronym DNA, not to be confused with the DNA that we refer to in paternity. That's the paternity testing to determine parenthood. The DNA acronym here is dependency, neglect, and abuse. What's that court about, Carolyn?
That court is for situations in which divorce is not necessarily an issue, and most of the children here are that we deal with in DNA court are either the parents have already been divorced or the parents have never been married, and they are children usually that the Cabinet for Families and Children, Social Services, has become involved with because they got a call or something happened where they thought the child may be in some kind of danger, either because they were dependent, i.e. mother went to jail, or mother is sick and there's nobody to take care of the child, so the child is dependent. The child is neglected because the parental custodian simply isn't taking care of the child, and the child is in danger because of that, or the child is abused. And in the abuse cases, of course, we also see concurrent criminal charges frequently with those cases. Dependency, of course, is a situation where sometimes the parents did not have a choice. Mom gets sick, they don't know where dad is, and the child just has no place to be. So either social services will bring a petition, or anybody can bring a petition to the court asking that basically the court find some remedy to help this child. And the first thing that is done is an initial determination, an emergency determination as to whether or not something needs to be done right now, this minute. And then there will be a full adjudication or hearing regarding the matter to determine if the parent that's charged with neglecting or abusing the child really did neglect or abuse the child. Mm-hmm. It is a civil proceeding, though. It's not a criminal proceeding.
Right. Now, for our viewing audience here, we don't want to give any indication that just because a grandparent perhaps or an in-law thinks that mom or dad's not doing a perfect job at parenting, that they have a grounds to get emergency custody.
No.
Kind of describe to the audience how severe these cases are to grant an emergency order.
Well, the child really does have to be in an imminent danger of serious emotional or physical harm.
Or sexual.
Or sexual, yes.
Mm-hmm.
So it's got, I mean, the level is fairly high. The bar is high. It's not just, I mean, there are many cases, for example, where social services makes a visit, says, you really need to clean up your house. I'll be back next week. We'll see how you're doing. I'm not going to take the children. They're okay, but you've got some things you need to deal with. So it's not every case. Mm-hmm. So just because you don't satisfy the criteria of Grandma or Uncle Joe does not mean that you're going to wind up in dependency, neglect, and abuse court. Right. It is a serious matter when you go to that court.
I have a question I need to ask. My experience with this is more from the side of where grandparents have filed these, and in most of these situations it's been a case of drugs. Do you as a judge, if you have absolute proof that the mother is doing meth, I'm going to use that's the most common one I see, automatically does that mean that the child should be taken away?
No, I qualify that with more circumstances are necessary. If she has placed the child in appropriate circumstances, like with a relative, a babysitter, an appropriate babysitter, such that she's not exposing her child to her drug use, then no, the child has to be in imminent danger.
It isn't typical. What I see, though, is that the mother who's doing meth, the child's living at home with her, she's starting to do a lousy job of getting the child to school. Maybe the child is tardy a bunch, the child doesn't go to school at all. The child eats Twinkies or Fritos, whatever's in the house that they can get themselves.
Right.
Does that arise to the level of imminent danger?
Yes, and maybe your example is not as clear as what I see in court, but oftentimes when these parents are utilizing that drug on a regular basis, there is no food in the house because they're not eating. They are not washing clothes. They're not picking up after themselves. And usually there's not even a path that can find a child from one end of the mobile home perhaps to the other end of the mobile home. Or, I'm not picking on mobile homeowners, but that's oftentimes a situation where the house is just just in total disarray. The child's bed oftentimes doesn't have linens, or they're so filthy or completely wet. And your cat or dog that's running around, the dog is not properly trained. He's not going outside. It's beyond the average person's belief of how these folks are allowing their children to live life. And basically these children are having to fend for themselves. The parents are staying up all hours for lengthy periods of time, not eating, not feeding the children. And then on top of that, sometimes the drug use is actually occurring within the house, which in and of itself is a safety hazard. If they're cooking the drugs there, and I don't necessarily mean cooking, but creating the drugs there, or if they are utilizing the drugs within arm's reach or within contact of the child, that's an extreme safety hazard.
Have you had experience with parents who are actually now starting to do drugs with their children?
Yes, I've had a very young, not even a teenager, that has been hooked on meth with a parent, and it's, or at least those are the allegations. The jury's still out on that one, but those things are. It's just traumatic for a child to have to be exposed to these elements of life. And what's interesting about that, because I have a strong interest in understanding what causes children to go in life one direction or another. But they say oftentimes, I've done some studies on children that are exposed to this, or I've studied about it. When the police are called and they come in, they don't react what police would call appropriate to their entrance. Police are barging into the place, and most children would be screaming for mom or dad for protection or covering. They're just non-reactive to it because their life has been so different than how we think children should be raised. They're just non-reactive to that sort of violent intrusion into their lives, and quite happy to see them oftentimes, because maybe this could be the change in their existence.
I'm sorry.
Well, I was going to ask what you do with children who are in that kind of environment.
Find a better place for them. Sometimes that's with relatives, if that's available. Other times it's in foster care if there's not a suitable relative placement, preferably a relative.
I was going to say, my experience recently has been that this drug use crosses all economic and socioeconomic levels. I think we tend to think of it that maybe there's only an under group that is doing this, but unfortunately I'm seeing it with people that they're educated, they have had good jobs, they usually lose their good job, people who would have been considered to have good standing in the community, and they're doing meth primarily, meth and cocaine. Cocaine seems to be the substitute, they can't get their meth. Doing meth and cocaine and just letting their children raise themselves. Or we had a case actually where the mother put the child on some type of depressant to keep the child subdued so that she didn't have to mess with the child. Mm-hmm. So she could do her meth and enjoy her life, and just the judge called it parenting by drugs.
Well, and it's not just illegal drugs that get people in trouble.
That's true.
I assume must be a really good drug, but I swear half the clients that I have, and I have a big criminal practice, half the ones that have drug problems, especially ones that are working members of the community, are hooked on freaking Lortab. I mean, it's a
painkiller.
It's a painkiller, and it's they start taking it because they have pain, and then they get immune to it, so they start taking more of it, and their physicians keep getting more and more, and sometimes then they get into trouble because they go to numerous physicians to get the Lortab. And you cannot,
or forge prescriptions when they cannot get it.
There are prescriptions and there's oxycodone is another one that's gotten out there that people are wanting to get. These are addictive drugs, and just because they're prescription drugs does not mean that you can take all of them that you want, and you can't. And this really impacts on children I think maybe in an unseen way, because the people who are doing these legal drugs aren't as likely to be under the scope of social services, and they seem to be more careful about how they do their drugs.
Right. We oftentimes see this in divorces, where one of the spouses who is seeking custody of the children bring it to the attention of the court, and it's fairly easy to prove, because you can hunt down all the prescriptions, and assuming they're not buying it off the street, which oftentimes that's usually not the case with well-to-do folks. They have their supply through appropriate medical professionals and can get it that way.
I'm thinking about a case we had years ago where she was a judge. My client kept telling me she's not addicted to prescription drugs. She's not addicted to prescription drugs. The judge subpoenaed all her drug records. When they came in, they were about 6 inches thick for about a year. I knew she was addicted to prescription drugs.
She may not have realized it.
Yeah,
she had been to rehab twice. I think she did know.
But I mean, really, a lot
some
of
people don't. You're right.
They really don't, and sometimes there's no question that sometimes they need something because they are truly in pain.
And I think what's really
and that's where
what's really the saddest of all in that situation is a lot of times that parent is the one who has been the primary caregiver.
Mm-hmm.
And so I think you're faced with the choice then of, wow, do I give this child to the parent who's been relatively uninvolved and take the child away from the parent who's been very involved with the child, or do I leave the child with a parent who has definitely been the primary caregiver, been involved with the child, and yet we know has this problem.
Right. And those prescription drugs, it appears on the face that people actually can perform basic, they go to work, they can cook meals, they dress appropriately. It's not like the myth scenes that we're talking about. They clean house, they do all the things, but there's something awry there. There's something wrong. So it's not. It's a dilemma in those situations where they're functioning, but not at full function.
Mm-hmm.
Tell me about the magic age. We get that a lot.
I get
that question. It's asked more than probably any question that comes in by parents. What's the age when my child can choose where they want to live? And people tell me, I don't know if I believe it or not, but people tell me that they think some other states have magic ages, that at 14 or 15 or 16 the child can say, I want to live with mom, I want to live with dad, and the judge is automatically going to do it. In Kentucky there is no magic age. Now the statute does list as one of several factors in determining child custody the wishes of the child. So a child's wishes as to where they want to live is appropriate. But there's not any magic age at which it becomes the only thing that you will consider. And say that's probably the most misunderstood concept in all of family law, is that there's some particular age that my child can say, well, I want to live with mom, or I want to live with daddy, automatically it's going to happen.
I have had cases, and I know you have, from a practical standpoint, if you've got a 16, 17-year-old that is just, for some reason, is mad, really mad at one of the parents and is not going to do right in that home no matter what, does that impact your decision on listening to what that child's saying? Does being a brat get you get you more?
Well, that comes up more often than you would even believe. In fact, it seems like I'm oftentimes dealing with that dilemma where parents are in custody battles, and one parent, the custodian, is not making a child perhaps go to school regularly, is not doing the fine parenting that we would hope that they would do. And as a result, the non-custodian is coming in and saying, Judge, let's change this. This child is on the wrong path. We need to change all of this. And certainly I agree. I totally agree. But a 16-year-old who is getting to do what he or she wants to do at the custodian's home and placed in the non-custodian home by court order, not by agreement, but by court order, is probably going to make that new custodian's life miserable, a living, you know what. Now, I warn parents about that, and despite that, they do want to proceed on with it. And recently, I've had situations where kids have rebelled to the point where they've actually charged their parents with abuse.
Really?
Because the new parent, the new custodian, is trying to appropriately discipline or inappropriately discipline, as the case may be. And so there's all kinds of ramifications of taking on a child, particularly an older child, when they don't want to be there. And the court doesn't have answers for that. Although there is a court that I deal with called Out of Control Children. So I guess you can bring your out of control child to my court and I'll try to straighten it out. But you know, I don't work miracles. So
Well, and that's an interesting court. I mean, that's part of what you do as a family law judge. You do the beyond control cases. And I have seen cases where, or talked to mothers, for example, that where their child is in DNA court. They're in DNA court, and there's also a beyond control case going on as well. And sometimes a social worker will tell, at least that's what my clients tell me, that the social worker told them to bring that they're going to get in trouble unless they bring a beyond control charge on their child. Perhaps, I don't know if you do that court. It's been a while since I have. Could you help me out and explain maybe what that beyond control is all about? I mean, if your kid won't behave, you get to take him to court.
that's it in a nutshell.
Golly.
Seems too simple, doesn't it?
Really?
But you think it would be abused by parents, but quite the contrary. I'm wondering why a parent's put up with this behavior this long, and then it's ironic. You know, you see little kids and they're at the grocery store and they're fussing and crying and wanting candy or this, that, and the other, and the parent is trying to appease the child in an appropriate way, and then maybe the child goes into a tantrum. Well, I get that stuff with 15-year-olds in my court. They're still having tantrums, and I often think, now, wonder if that parent understands that if he doesn't do this right now, he's still going to be living with these tantrums when they're 15, except they're a lot worse at 15. And those are the kinds of kids that I get. They're not going to school. They're playing hooky either after they get there, or they just won't wake up, which is a whole other area of problems that I deal with, truancy. They're talking back to their parents, cursing their parents, getting in physical fights with their parents, damaging property in the home, not coming home for days at a time, not coming home for their curfew if they have one, having their girlfriend or boyfriend to spend the night perhaps in the house with them. Hope I don't give any kids any great ideas here. But just a sundry of things. Having raised a son myself, I think I would have killed myself if I had kids sometimes that are that bad. But those are the kids that come into court for being out of control. I put them under court orders. Hopefully they'll understand that I really mean business, and if they continue to violate a court order about following rules of the home, about going to school and no drugs and so forth and so on, I'll set it out. I give them a copy of it. if they understand it and they follow it, no problem. They'll never see me again. On the other hand, when they violate it, I actually have the ability to pick them up and place them in detention until I see them, which is within 24 hours. And that happens a lot.
Do you all feel, I mean, you have children, and
I do.
And I've raised 2 boys, and you got raised a boy, and so we've all kind of been there. And I'm not a young person anymore, so you know, I can remember back in the good old days when it seemed that all family matters were handled privately by the family, and it appears to me that more and more that the system between social services and family court and juvenile court and police officers are involved in parenting. And I don't understand why that is. My personal opinion is that, you know, that children are aware that there are limits. They are no longer afraid of their parents. I personally think a little fear is a good thing. You know, whether it's brought about by love or guilt or what, but especially when the children get to be 15, 16 years old, I mean, what are you going to do, you know? And I was wondering what you all's thoughts were, since both of you work in the system, especially you, Judge Sanderson, as to why we seem to be more involved. Or is it just my imagination?
No, it's not your imagination. I think it's exactly right. Well, I think it was Hillary that said it takes a village to raise a child. Well, I don't think she meant it takes all the social services and public agencies and everything else. I think she was talking about the next door neighbors. Unfortunately, I think society has become way too dependent upon agencies, whether that's the welfare department or the social services or the police. I mean, how often are people called in family disputes? The police are called, and it just amazes me. I can't imagine what it must be like to live in a home where it's a frequent occurrence that the police have to come to settle a dispute in your home.
And then the parties are upset when somebody gets arrested.
Yes, yes,
Yeah.
yes.
Because I think they're still thinking that the police are going to come out and they're going to just fix everything and go.
Yeah.
I do think, I don't know, society becomes more complicated all the time. We know that we've all practiced law long enough to remember when a file was that big and you got it finished. Nowadays, every file is big and they just get bigger and bigger. Everything's more complex. Even going through your junk mail at home is more complex.
Oh gosh,
so
yes.
Raising your children is more complex. You've got the internet to have to worry about now. You have cable TV or satellite TV that's got more stations and still can't find anything decent to watch. So you have all those factors, I think. You know, I do think we need to talk about, though, because I think of all of these, the hardest cases of all are where we have good children and good parents who get divorced, and then the judges call them to be Solomon and to divide those children between good, loving parents with good children. And to me, those are the cases that are really. Most of these other cases, I think, were relatively easy, unless both parties are just total derelicts, and then you hopefully find a good grandma or a good aunt or uncle. But to me, the hardest cases of all are where you really do have two wonderful parents with good children, but they can't live together anymore. There's going to be a divorce, and who's going to get primary residential custody? Because we know that the way the system works, I mean, and I've looked at it a million different ways to try to find a good way to share time with children. I think a lot of other people, a lot smarter than I, have looked to try to find ways to share children, but ultimately, most people think children need a home, they need their beds, they need their pillows, they need their place to feel secure, and they're going to live with one parent most of the time, and they're going to visit with the other parent on weekends, on some extra time during the week, hopefully special, certainly split holidays, divide summers and things. But to me, those are the most difficult case of all, and I'm wondering.
I think you're right. I think the saddest cases are the ones where the children don't have good parents. Those are truly sad cases. It's enlightening when you deal with those type of cases a lot to see good parents come through. It's unfortunate they have to fight over their children though, but they are very difficult because as you know, there's no preference. There's no, it's just a simple best interest standard. And
Well, and there are, most people would say, if you asked on the street, who gets custody the most, they would assume that mother does. Do you find that that is the case? And I mean, I see a lot of cases where that's not the case, but I don't know the statistics. How does that play out for you?
I don't think that's necessarily the case in my court, but now Mr. Reed may have a different
Well, I
decision.
think in uncontested cases, cases where there's not a dispute, more often than not, the mother ends up with custody.
Because father agrees to
The
it.
father agrees to it, and that I would say is the most common case
Sure.
of all, because I don't know how many divorce cases come through your court a year, but fortunately I think only a small percentage end up with custody battles that get fought out to the bitter end.
Right.
Sometimes they start and then they get concluded by agreement, but I think in the case of agreement, more often than not, the children stay with the mom. But ultimately, daddy agrees to that. If daddy doesn't agree to that, then those cases get fought in court. And I think one of the things that happens, I think the judge does have some statistics, and I'm going to keep talking a second before I let her give you the statistic. I think one of the things that happens is most lawyers will recommend to dads, unless they have a better than even shot, don't try to get custody, because all you're going to do is create ill will that will last a lifetime. And you're going to create harm for your children. You're going to put your children in the middle. So unless I have a dad that I really think has a shot, I just tell them up front, you're not going to win. You're going to spend a lot of money. You're going to have a lot of heartbreak, and you don't want to do this. Someone has to be willing to sacrifice a little bit. And so I think you only see, I think, the cases normally. I think most of the contested custody cases the judge sees, you really have what I described earlier. You have really tough cases where both parents are either excellent parents or mom has a little something against her. Maybe she is the lady that uses too many Lortabs, or maybe she drinks a martini too often, and yet she's been the primary caregiver. So I think once they get to the judge for a decision, they're really close cases. And then you can tell us, you did a survey one time of how often in the contested cases.
Right. I was giving custody to men more often than I was, and I think that that has stayed fairly consistent. Now, I think John's exactly correct. I think that men are not as likely to pursue cases that that they don't have strong cases on. Now, I hope I'm not deterring that. I certainly don't intend to. However, you know, if they're seeking out legal counsel and that's what's being told to them, maybe that's the reason. But
well, I think we would be naive if we didn't say that most folks think that children belong with the mother. I'm not saying that that's right, but that's what most folks think, because most of us, particularly older, my generation, we had moms that either stayed at home or they didn't work as many hours as dad did. Mm-hmm. So I think we start out with a proposition, and I think this is true of all courts around here, not your court, but every judge that I practice in front of, that more often than not, if every case where people got divorced came to you on a custody decision, I think women would win a lot more than men, because women
true, yeah.
tend to be the nurturers and the caretakers. And I think that's still true. So I think to say a lot, you know, there are guys out there that want custody for the wrong reason. They don't have to pay child support.
That's a big reason, yeah.
So you have to let them know, look, have you been changing diapers? Did you get up for feedings? You know, did you go to the school conferences? Did you ever take the child to the doctor? Did you ever take the child shopping? Did you ever go out and play ball with the child? Their dads, even though they're dads, the moms played ball with them. Mom took them to every soccer game, every baseball game, every t-ball game. If a dad wants to win, he better have done those things, or else I'm going to tell him, forget it. If he's a dad who worked hard, supported his family, but when it came to raising the children, his wife really did most of that, I'm going to tell him up front, you're not going to win, and you're going to put your family in harm, because I think you see it. Some of these most contested custody cases, they continue throughout the children's lives in one form or the other. They can't come back to court to you, but every 2 years basically. But you do see them over. If you start with young children with a highly contested custody case, you see that case keeps coming back in front of you every 2 or 3 years.
Well, you say they can't come back to court, but
Well,
every 2 years. There are some folks who have regular court appearances every 2 months over visitation or contempt issues for failing to do something, and they just seem to be a regular fixture in the court system and appear to enjoy it. Contrary to myself, it's not an enjoyable experience to continue dealing with people, which brings me around to the issue of trying to fix people. You mentioned earlier that just this week there was a couple in court that one party wanted me to fix the other party. Well, that's not what I do, and I can't do it. And chances are, when he or she were married, they were just like that. Unfortunately, they tolerated it, and now they don't tolerate it.
Well,
So-
and the domestic system, the domestic branch of our legal system is still a legal system.
Right.
We deal with legal issues. We get divorces. You get a piece of paper that says you're divorced, and there's statutes that tell us how to do that. Adoptions, custody, paternity. These are legal issues. We cannot make your relationship better. We cannot make him be nice. These are things, and those things play into your legal issues. But when you come to a lawyer expecting, or a judge expecting the lawyer or the judge to make your domestic life run smoothly, it's not in our power to do that, and it's not in the power of the law. It can help by basically sending you to your rooms, but it cannot fix your personal problems. Speaking of legal issues, John brought up that you can't come back to court for 2 years. Perhaps we should explain what we mean by that.
Well, on a custody decision, once the judge makes a custody decision in Kentucky, you can only come back to court within 2 years if you can prove the child is being seriously endangered. And the Court of Appeals and the Supreme Court have been very clear that serious endangerment means something other than I don't like what the child's eating for breakfast, or I don't like the pair of shoes the child wore today. It means the child is seriously endangered. The child's not being fed, the child's not being clothed, the child's not being taken to school, the mother is hanging out with a known child abuser or something. It means exactly what it says, serious endangerment. But the judge is right. There are other issues such as visitation, child support, that do get to be brought back to court whenever the need arises, and sometimes when there is no need. Some people, as the judge has pointed out, just like to come to court and fight with each other, which gets back probably, those are the people who think you should be able to change the other side and make the other person a nicer person. There are things you do, and we maybe should point those out. You make people meet sometimes for visitation exchange at McDonald's, so hopefully they won't show out and scream and curse at each other. You make them sometimes just stay in their cars if their children are old enough and the children walk from one parent's car to the other parent. I would hope if there are any of those parents listening that they would realize what harm they're doing to their children and what a lesson they're teaching to their children. I remember we had an older judge here one time who told some people in court when I was representing some folks, you're raising your children to be this same way. Do you want your children to act this way when they become your age? They think this is how normal adults act, and it's not. We know, fortunately, that most cases that go through the court are uncontested, meaning the people get divorced, they settle the case, they go their own ways, and they hopefully try to do the best for their children. But then we have the cases that are contested, and some legitimately so, and some not so legitimate. But I will admit, as a young lawyer, I thought I could change people. I thought the court could. I didn't think I could. I thought, well, that judge can make that guy be nice when he comes to pick up his children. And I learned finally, and I tell people that all the time because it's something everybody wants. They want you to correct the fault that caused them to divorce the person. You know, well, if you had that power, we would all be out of business and your court would close down pretty quick.
And that would be fine, actually. But being nice to people, the ex-spouses or the parents of children, it's a novel idea for a lot of people. Some people cannot even talk. They can't be in the same room and talk civilly to each other. And unfortunately, the children are watching all of this, and I think they're kind of clueless as to the impact that has on the kids.
I do think email's a good thing because some people can communicate by email where they were not able to on the phone. And the other wonderful thing about email is you have a record of what people said. And I'm often amazed, people come in, they bring me all these emails to read, and they're wanting to say the other person's the bad guy, and I read this and I'm like,
how would you say
why would you want anybody to see what you wrote to the other person?
I know.
Oh my gosh.
I've had that before too. And you recommend the couple that was in Motion Hour the other day, that's exactly what you asked them to do, was to communicate by email.
Right, because they couldn't talk.
They just have to argue every time they get on the phone.
Yeah, and so maybe the email is the answer for something at least. Let's talk about, when we're talking about being nice, the bad person in the divorce, the person that's at fault. How does fault play into to a divorce action?
I was going to say, I never represent the bad person, do you? No,
Once I
goodness.
did.
Oh, okay, one time.
Once I did,
Oh,
yeah.
well, that's another issue that people really lose concept of, that we have a no-fault system. And so consequently, when it comes time to divide property, to divide the 401k account, to divide the bank accounts, to divide the equity in the house, it doesn't matter that the other party has been messing around and been an unfaithful spouse. You're still going to divide everything down the middle. And I'm amazed how often I explain that, maybe not very well to people, and as soon as I get finished, they say, well, that's mine. When I go down the list, that's mine. Well, why is it yours? Well, I made the money. I paid for that out of my checking account. Well, your checking account is her checking account, and her checking account is your checking account, and your paycheck is hers, and her paycheck is yours. You know, that's the way it is, and fault does not enter into any of those property divisions. But I do have to there's always an exception in the law, and that is, that would not be true if one of the parties was a drug addict and had squandered a bunch of money, or one of them went to the riverboat across the river and squandered a bunch of money. In that case, you are able to say, well, you got your part of yours, and I'm going to give the other spouse more. But as far as marital misconduct, messing around, stepping out, I hadn't heard that term in a while. One of my clients admitted to me the other day he had been stepping out on his wife. I really hadn't heard that in a while.
But now if they step out and spend a lot of money while they're out, then that's the equivalent of squandering the assets because they're spending it on non-marital purposes. In other words, the girlfriend or the boyfriend.
Right. But I think it has to be a pretty extreme amount. I don't see you're going to, if they took somebody to Applebee's for dinner, I don't think you're going to change the award.
But if he bought her a house to live in.
Well, that would be different, wouldn't it?
Or took a $5,000 trip on a cruise ship or something. Yes.
Yeah.
But is there another exception to the fault?
There is
issue?
another exception to fault too, and that's when a party is asking for maintenance, which is the same thing as alimony. I don't know why we don't call it alimony in Kentucky, because everybody knows what alimony is and nobody knows what maintenance is. If a party asks for maintenance and that party has been stepping out, then you can bring that up. But the problem that troubles me, Judge, is the statute gives no guidance as to how you're supposed to reduce their award. It would be nice if it said, well, whatever you were going to award, you award half as much, or you award 25% as much. Instead, it just says you're to take it in consideration.
Yeah.
And so I've always had real trouble trying to conceptualize, well, how how's it going to play out?
Well, first, doesn't it have to actually contribute to the breakup of the marriage to be relevant?
I would think it does.
Well, if he didn't know about it, or if he stepped out, if they were both stepping out, for example, and it was agreed upon, that wouldn't.
Well, that would be different, I think, if you had a.
Well, that's the interesting concept. If the person seeking maintenance is at fault, then you can introduce evidence against the other one, the person that's not seeking maintenance, to controvert the fact that
that was a cause?
That was the cause. In other words, let's say that the wife is seeking maintenance and the husband says, well, she was stepping out. And the wife says, I was stepping out because you started drinking at 5 o'clock and you were snoring by 6. And so you passed out by 6 o'clock every night. And so his alcohol abuse and his lack of attention to her can likewise be considered as, to counteract her misbehavior. Not that it necessarily does, but.
Or maybe she reminds him that he had the first affair 5 years ago, and she only started hers after he'd had a couple, and then she started her. I mean, she started her affair after he'd had a couple in the past.
So it's not an absolute rule. It's this consideration.
Yeah, and I'll get my 2 cents worth in. The statute never mentions fault, and this is man-made law. This is judge-made law from like 1976. That says that you consider fault in maintenance, because if people want to get online and read the statute, you'll never find fault, except you'll find no fault. You'll never find fault in our statute anywhere, but clearly that's the interpretation where fault does enter into it.
The thing that I find interesting that I have to explain to women who want maintenance, it's like, I should get a lot of money because he was having affairs. I didn't do anything wrong. He was having an affair, so he should pay me more. He should pay me money. And I'm saying that's, the fact that the person that you want the maintenance from, the fact that
relevant.
It's not relevant at all, and that does make it's very difficult to explain the reasoning behind that.
Right, and I'm sure most lawyers try to do that, but inevitably, I get to hear about it. Just in a long sentence, it comes out somewhere along the line that the other side was stepping out. So.
Well, I mean, we do have to try to let you know the bad parts of the other party, and if we didn't do that, we wouldn't be doing our job. But yeah, you're right. A lot of people don't understand it can't be used to increase maintenance, so it can only be used to reduce the amount of maintenance to the person who's seeking it. Because you're right, a lot of people want to know, well, why can't I get a lot more, because he's been horrible for 10 years and I've put up with that crap and I'm tired of it. But you get to tell them, you're going to get the same amount you would get whether he was the world's best husband or the world's worst husband.
And speaking of gimme stuff, I find, and maybe it's a throwback where our society is still transitioning this equality thing.
I'm going to have to cut you off.
Okay.
Because we've had so much fun in this this past few minutes that it's time to say goodbye to our audience, and thanks for watching the People's Law School.